Good evening, my dear friends. It's gratifying to note to be part of this great initiative of a webcast program on Insolvency and Bankruptcy Code. Today is the 6th of April 2021, Tuesday. In some of the states, election is on and it is up to 7 p.m. And will request those who have not casted, tell your friends to go and cast the vote to have a maximum turnout to decide the democratic process of a constitutional duty to be performed. With this overall note, just day before yesterday, 4th of April 2021, there was an amendment by an issuance of an ordinance promulgated on insolvency and bankruptcy. Generally, an ordinance is issued where the sessions of parliament is not in operation or conducting their activity, and it is very important to enact this particular amendment in IBC. You all know during this last year, which we are experiencing today also about the global historical pandemic, there was a suspension of this IBC process from 25th March 2020 for a year, got expired recently. And also, the threshold limit has been hiked from, in respect of CIRP, from 1 lakh to 1 crore. Because of this, most of the matters were kept in abeyance. They could not do anything. The resolution process has been time and again told is not a recovery of the due process. It is a resolution, finding a solution to a situation. So many companies and most of the growing middle level segment of manufacturing, distribution, whatever companies, they were finding it difficult during this historic pandemic. Keeping that in view and the necessity and time aspect, it was thought fit to by the government to promulgate this particular ordinance. The other speaker of the day who is going to share his vast knowledge about this topic to give an insight about this amendment with all rich experience which he carries on is Dr. GOPAL RAJU, who is very familiar to most of us, and he has taken the pains of melting the candle yesterday night to share within one day. It's a day before yesterday means day before yesterday evening only. Yesterday only the only available within less than 26 to 36 hours. Amidst his professional commitment, he has wished to share his expertise on this one. Dr. GOPAL RAJU is a chartered accountant, cost accountant, company secretary, resolution professional, valuation professional. The list goes on, never ends. And he is a passionate teacher. Welcome, Dr. Raju, and let us go to the topic specific. The IBC law has been enacted in the year 2016, roughly about 4.5 to 5 years got elapsed during this intervening time. And there were a lot of experiences this way, that way. Everything is there, is mixed bag. And due to this pandemic, and as I told you, because of the need, this has been enacted, and today's purpose is to unfold with an insight about this particular new ordinance. With this, not to take much of your time, I go to straight to the question. Dr. Raju, I want to know why there is a need for this one, and what are the objectives of this particular ordinance, to whom this is all applicable, whether it is type of all persons or defaulters or kinds of persons. Because in CRP it is applicable to certain kind of people. There are other kind of individuals. There are individual certain segments applicable. Likewise, what are the objectives of this particular ordinance and to whom this is applicable? Can you share your reply on that?
Thank you very much, sir, for the nice introduction and to bring the platform to all the virtual members. So very good evening to one and all, with reverence and respect to Sampath Kumar ji. He has been very supportive, especially in the initiatives taken by myself and Mr. DHANAPAL. Welcome, Mr. DHANAPAL. Thank you for joining on time.
Welcome.
The question that was put to us is very, very important. Why pre-pack insolvency resolution process has come? This is the first question. And this three-letter word, why, we need to understand very clearly. Point number one, please understand, is exactly 1 year back, 24th of March, we have got an amendment where when the suspension was made for IBC, originally they planned for 6 months and they extended for 6 months. They brought one more amendment, very important amendment, that the applicability of the CARP, they have increased the limit from 1 lakh to 1 crore. Please be very clear. They have increased from 1 lakh to 1 crore. That means any default from 25th of March 2021 onwards, 25th of March 2021 onwards, if it is above 1 crore only, the CARP can be initiated. If there is a default below 1 crore, that is why they have brought this particular ordinance, a very, very important ordinance, I must say, where they have brought a particular amendment to section 4, where with respect to pre-pack, and I want to make one very important analogy here. The Bankruptcy Law Reforms Committee, when they brought out their report, based on that, a house was constructed. That is called the Insolvency Bankruptcy Code house. When they constructed the house, there was a 2-step, that was the entry for that bungalow. And the first step is CARP, the second step is liquidation. Immediately after liquidation, there will be one sump. You have to be very careful, otherwise you will go on Dobukati, you will fall in that sump. Now what has happened, the first step, they have kept it very high. So therefore, there is a necessity to make a small masonry work to add a small step, making it convenient, especially for micro, small and medium enterprises. So here, this entire ordinance, very rightly Mr. Sampath Kumar has brought out that because anything with respect to 240 capital A, because that is a section under IBC, which is applicable only for micro, small and medium enterprises, which makes it very clear that any change, it has to be placed in both the houses. It has made it very clear. But just because the parliament is not in session, and this is a very unique time where election commission is also taking its control for majority of the states, the need has been identified by president, especially post 25th of March. What MSMEs will do? MSMEs, they have dues, they have to recover. So that is why they have brought a very important amendment to section 4, which says that provided further, the central government may by notification specify such minimum amount. So that means you will get a new notification with respect to applicability of this particular ordinance. So far, only ordinance has come. There are 2 words that is used in this ordinance. One is called prescribed. Another is called specified. Prescribed means rules has to come. 2 rules has to come. And specified. And specified, they have given a very big list. And you will be surprised. There are 15 items for which you can expect regulations. You can expect regulation. So therefore, your ordinance with respect to MSME, the rules and the regulation put together will become a mini IBC. Number 1. Number 2, whom applicable? It is applicable only for micro, small and medium enterprises, exactly on the Doctor's Day and Chartered Accountants Day and the Engineers Day. That is 1st July 2020. There was an amendment that was brought to section 7, subsection 1 of Micro, Small and Medium Enterprises Development Act 2006. What is that? The micro, small and medium enterprises, they have actually Original category was investment category. Now investment and turnover category. Now what is that two category? Number one, the investment with respect to micro should be less than 1 crore, and please appreciate that, and turnover should be below 5 crore. And if any one of that I cross, I will go to small. That is 10x from 1 crore into 10 is 10 crore. So below 10 crore, 1 crore to 10 crore, I am a small, especially investment in plant and machinery. Similarly, 5 crore into 10 times, which is 50 crore turnover. So both the criteria I must satisfy. Investment should be below 10 crore and my turnover should be below 50 crore. Now, any one I cross, either turnover I cross or my investment I cross, I will mature to a medium enterprise. That means up to 50 crore investment in plant and machinery and turnover less than 250 crore. And this syncs with the income tax department also. This is the first fundamental criteria. And the section, I must tell you, the part 2 of the Insolvency Bankruptcy Code, Chapter 3 is liquidation. Chapter 4, I repeat, Chapter 3 is liquidation. Chapter 4 is fast track CARP. Till date, fast track CARP, if you ask statistics to Government of India, they will be silent because it is only in section, very limited application has been made. So this is actually a fast track. Our original time limit was 270, increased to 330 days, has now been crashed. So as and when Sambat Kumarji will lead the question, I will try to actually supplement it. So thank you very much, sir, for the wonderful opportunity and for hosting this particular program. So over to you, sir.
Thank you, Dr. Raju. With respect to the objectives, very detailed, and to what is an MSME, how it is applicable, what was the background, how the likely changes that is in store with respect to rules and regulations or whatever that is by way of prescribed and what is specified. Nice. Thank you very much. Now, Dr. C.S. Dr. DHANAPAL is another participant today. He was gracious enough to be with us to share his expertise and about the topic of the day. And Dr. DHANAPAL is a company secretary, is in practice for more than 2.5 decades, and is a valuation professional and naturally an insolvency professional with rich experience behind him. Welcome, Dr. C.S. DHANAPAL. And directly a question to DHANAPAL. Yes. Friends, you all aware, Section 7 of the IBC deals with an application by the financial creditor, and with respect to Section 9, it is by an operational creditor. And there is one more section, Section 10, by the corporate debtor himself. Dr. DHANAPAL, when this is the background, what is the ordinance says with respect to who can be the applicant who can initiate this particular application for the resolution? What is this called? Pre-pack resolution. What is this pre-pack resolution? Who can initiate this? Over to Dr. DHANAPAL.
Yeah. Thank you, Sambat Kumarji, for your introduction and for your initiative to bring it before audience immediately after the ordinance has come into effect. To answer the question that you raised by you, Section 7, 9, 10, as right you pointed out, Section 7 for FC and 9 for OC and 10 for corporate debtor. See, there is already the process in vogue whereby the IBC can be initiated. As correctly Dr. Raju pointed out, that the threshold limit has been increased from 1 lakh to 1 crore. So now, as you are all aware that after March 24th, if any company or any person want to initiate a IBC proceeding, there should be a default of 1 crore and above. That should be the new threshold limit after March 24, 2021. So government felt it necessary that to give option to revive companies which are not coming, which are coming under less than 1 crore category. Purposeful, and particularly if you have to say, to address the MSME category, because earlier, in fact, I remember many years the government was discussing about that they want to provide some kind of comfort to the facility to the MSME. Now it has come in the form of Ordinance 2021. Actually, it was expected earlier in a different form by giving certain relaxation to MSME under Insolvency Bankruptcy Code, but now they brought out a specific process which is called Prepackaged Insolvency, as you said. So now this Prepackaged Insolvency is particularly articulated and architectured only for MSME category. MSME, Dr. Raju has explained overall coming under the MSME category, so I don't want to go into much detail about it. So why this MSME category should be addressed? So if you see that MSME is the category, those who are not doing business in a bigger level, those who are not put investment in a bigger level, probably we can call it a small player. So government thought that to this COVID scenario, government thought to give a helping hand to MSME. That's the basic idea. So the government is thinking that the MSME should not be put into the pressure because of the IBC process, initiation of IBC process under section 7, 9 and 10. Okay. So what the government felt, okay, let us bring a separate process which called the Prepackaged Insolvency process, whereby the MSME, now the threshold limit under MSME is the government had to notify, but that cannot be more than 1 crore default, because anyway 1 crore and above is coming in the normal insolvency process. But this prepackaged insolvency process, default, the government has to fix the minimum default amount, but that too subject to the limit of maximum of 1 crore. So that's what the ordinance says. So therefore, if any default lesser than 1 crore, time being, I'm presuming is 1 crore. Suppose the government announces it is 10 lakhs, then it is 10 lakhs or 20 lakhs. Whatever the government is going to announce, that's going to be the minimum figure to trigger the insolvency, prepackaged insolvency process. So suppose the government comes into one particular threshold limit. If any default committed by the MSME companies, not normal companies, MSME companies, then MSME companies can initiate their own prepackaged insolvency process. In fact, now today, what is available under section 10 for any company, now by virtue of this ordinance, this prepack provision has been given in the hands of corporate debtor who belong to the MSME category through this ordinance 2020.
Thank you, Dr. Dhanapal ji. You are in, as I understand, you are highlighting about the extended protection given to MSME, point number 1.
Yes.
And it is to be initiated by the MSME himself too, before the CIRP or 7-9 application is being taken.
Yes.
This is a self-regulatory mechanism provided to more than 60-70 lakhs of MSME across India that is situated, where there is a helping hand that is needed. Otherwise, they may have their own difficulty. They are recovering, in the process of recovering and growing, at which time they should not be disturbed. That's the simple essence about what I grasped from your nice inputs. Now, Dr. Raju, how is the adjudicating authority? There should be an application process in any resolution plan or resolution process. How the adjudicating authority deals with an application if at all filed, whomsoever it is, has rightly pointed out in this case, it is by the MSME and moved before it by a CD. When matters are already pending about the particular CD, or what is the process involved, and any intricacies with respect to the ordinance now?
Amazing question, actually. And I want to actually supplement what Dr. Dhanapal made it. Because that particular section 4 says that was the original section. If you read the original section, it was same, and now they have brought it for pre-pack. My understanding is the government may start with same 1 lakh for pre-pack, so that more number of beneficiaries will be benefited. This is my individual view. Number one. Number two, coming to your question, already section 7 or section 9, section 10 petition is pending before adjudicating authority, NCLT. Now, I want to move a pre-pack. Is it possible? Answer is no, because we have the answer in section 11A, which has been introduced. A new section has been introduced where the transition provision has been very clearly mentioned. The section 11A subsection 4 makes it very clear. The provisions of this section shall not apply where an application under 7, 9 or 10 is filed and pending as on the date of commencement of this ordinance. So therefore, pending application before 4/4/2021, pre-pack not possible. Now, coming to the next concept. Now, I first make a 54C where the application has to be actually initiated. Actually, under 7, 9 and 10, you said financial creditor can initiate or operation creditor can initiate or a corporate debtor can initiate. But here in pre-pack is like generally you go to the olden days, you want to buy rice or dal, you will decide what to, and you will go to the local grocery and you will order, and they will take a cone like paper and they will make it. But today you make a list to go to a departmental store, already pre-packed rice, dal is there, and you just buy it, go to the counter, and their counter, the approval has to be given. You have to make the money, and then only you can take home. Very similar is the same 3-step process only actually, but it has been elongated. Now, first I file a 54C application. Who can file? Only corporate applicant. That means company only can file. Number one. After filing this 54C, independent, very nicely Dr. DHANAPAL mentioned it. This is actually two tool is available for our MSME friends. They can either come under pre-pack or they can go for a bulk pack also. That is CIRP. So PP, IRP, CIRP. We have to use this small, we have to have this acronym. So I make an application 54C. Then I also, the financial creditor who makes an application under 54C, corporate applicant. Now financial creditor, no, you will make an application. I will go, he will go to NCLT and he will make an application there. Now, which will prevail? Because after this, all this Jagada Jamela will happen, and I am sure whether the company is going to make money or not, professionals and legal luminaries are going to make very good money. Number one. Number two, both the applications are pending before NCLT. Now, which application I should take first? Section 11A subsection 1 says, if 54C is pending, that has to be disposed first, and then only I will consider financial creditor. Naturally, since moratorium started, it will be done. Govinda. Now, reverse. First, financial creditor has already filed an application pending. Now, I am an MSME. I am eligible actually. I should have filed, but I have not filed. Now, I am sure Dr. DHANAPAL also will agree with me. Many MSMEs will go and file but you have to file it within 14 days. You have to file within 14 days. So
Dr. Raju, sorry to interrupt. My understanding now, I got a doubt to clarify by myself. Already application under 7, 9, 10 is pending in NLCT, which has been filed fairly long time. That has to continue. And somebody initiates 2 days, 3 days back before NCLT and less than 14 days, then there is an option available for the CD to initiate a pre-pack process in such a situation. Pre-pack alone will be heard by the adjudicating authority.
First will be disposed of.
Keeping in abeyance for a while 7, 9, 10 application.
That will also be
on the other hand,
if
14 days are over, then 7, 9, 10, which is the CARP application or whatever, that takes the precedence than the pre-pack application. Am I correct, Raju?
Absolutely correct. Maybe if it has been rejected, say section 7 application is rejected, maybe then the pre-pack will be taken.
Oh, fine. So that's also possible. Thank you. Let us move on. There are a lot of questions. I think available time already we have crossed some fairly good amount of time what has been scheduled. Now, Dr. DHANAPAL ji, what are the conditions applicable for the initiation of a pre-pack IR resolution process. What are the conditions? Anything has been stipulated in this ordinance?
Yeah, see, before answering your question, Sambaji, I just to supplement what Dr. Raju has said, pre-pack insolvency. Dr. Raju has put it in a very common man language so that to make it easily understand. To put it in a legal language, what I understand from the connotation called the pre-pack insolvency, what they are trying to say is pre-pack insolvency. It's my understanding. Probably government may have a different meaning for that. A pre-pack insolvency, what they are trying to say is that before you are testing into the insolvency, you have your own pack. Means the government is giving an opportunity to the MSME. You come out with your own pack before you are marching or before you are marked as a insolvency. Meaning that Section 7 and 9 and 10 applications are targeted to mark a company as a insolvent, right? So it brings the company into the CARP, whereby the CARP process kick-started. Means insolvency process itself is kick-started. Whereas pre-pack, the word pre-pack is used. Probably what I mean to understand means why this word, it is languaged as a pre-pack. Meaning that before getting into insolvency, you have your own pre-pack and approach financial creditor on your own. If your financial creditors approves it, and the financial creditor has to nominate one of the insolvency professional also while they are approving. That's the condition. That's the condition where while financial creditor approving the pre-package, we call it as a base resolution plan. While the financial creditor is approving that pre-pack, whatever that base resolution plan submitted by this corporate debtor who is MSME to financial creditor, the financial creditor has to nominate an RP and say that to move further on the pre-pack insolvency process. Then after that, the application has to be filed by the corporate debtor to initiate the process, whereby the RP to take the process forward. Of course, I will narrate you probably in your next
Thank you,
Dhanapalji,
I'll take like this. In a CARP process, the process initiated under the 7, 9, 10 applications, whereas just prior to that, there is an option or a facility that has been granted to this type of MSME. You start your own process and experience that. If you are able to do that, so that support is extended without much of legality or procedural. On your own accord, you initiate something so that you are able to solve it.
Correct. Sorry to interrupt. However, the government felt that you have your own pack and you approach financial creditor, but there should be insolvency professional who is a competent person, who is trained person, who know how to do the process, who got experience already in CRP.
Naturally, because the procedures and the applications have to be supported by all the stakeholders, conducted by the professional support only. Not ordinarily, however best the knowledge of the business person is concerned, with respect to procedural aspect, they have to rely and depend on the practitioners. Dr. Raju, I would like to know, under the regular CARP process, you made an observation, initial observation about 180 days and 90 days, 330 days. 180 days is the normal time period granted under CRP process, with a specific extension of one-time extension of 90 days, not exceeding overall with respect to any litigation other things, 330 days by the amended provisions. Now, the same is less with respect to fast track process. As you have rightly observed, there are no specific data available with respect to fast track resolution process. And you have made one more good comment that this ordinance may give a role or room for this particular MSME fast track. Now, I'd like to know, keeping this background, what is the time limit that has been prescribed for this pre-pack process, Dr. Raju?
Sir, very rightly you have made this what do you call this comparison. Today, government is very keen that unlike the section 54, that is your fast track, 55 to 58, which is the fast track CIRP, which has not gained that much of significance. The government is very clear that this pre-pack should be the most popular model, most popular insolvency resolution process model. That is the reason it is not a what do you call it as a monorail, but it is a rail with a double track. What is monorail? Once CIRP is ordered, the board is suspended and the entire powers vest with the insolvent, the IP, that is the interim resolution professional, then with the RP. But here, board continues. And that is why you have a parallel two track. The train has to run on the track. Train is actually the business. And there is a mandate that the going concern has to be upheld both by the resolution professional and also the responsibility of the committee of creditors, the management. But of course, there are further provisions which says that when the entire process of the management can be put off and the committee of creditors can take the lead. Committee of creditors generally will take a backstage. Here, it is very rightly Dr. DHANAPAL has said, pre-pack means come with the solution. Come with the solution. Today, 80% of the CIRP is not solved. It is still there. Dr. DHANAPAL will agree with me. 80% of the CIRP cases. And the beneficiaries should be the creditors and the company. But actual beneficiaries are professionals and the legal professionals only. Maybe people may take it in other perspective, but this is the fact. Now, point to be noted, 330 days was the time limit for CIRP. Now, here they have crashed it to 120. And in this 120, I must make it very clear, they have not only crashed to 120. In 120 is actually 4 months. In 4 months, 3 months you must resolve. You must actually approve the plan. That means 90 days you must approve the plan, and 30 days you have to submit the plan before my lord, and my lord will give the order in 30 days time. So total 120. Number one. Similarly, once it is called as pre-pack insolvency commencement date, PPICD, like CIRP commencement date. So here it is PPICD. PPICD within 2 days. Within 2 days, the base resolution plan has to be submitted. That is why Dr. DHANAPAL mentioned it. Once you have decided, you have to go to you have to make an application. Approval has to be a special resolution. Special resolution means 75%. In company, there should be a special resolution, and financial creditors has to propose an IP. And after the special resolution, again I have to go to the financial creditor. See, this is the base resolution plan, and this is we have decided to go for pre-pack. Please give an approval. So 66% approval has to be given by the financial creditors. So that means there is a handshake model before going to NCLT. What you call it as a one-time settlement with the, now here you can make a one-time settlement. See, generally what happens is, even after CIRP, the company goes before the banker and say, can we settle, can we do an offline settlement? Today it is possible. In CIRP, it is not possible. That 1TM, OTS, GTS, nothing is possible. But today it is possible in the name called pre-pack. So that is why you come with a basic solution, what you call as a base resolution plan, which has to be actually accepted. Maybe when it comes to the approval, because after the Honorable NCLT gives the PPICD, our resolution professional has to prepare a report, and then the base resolution plan has to be placed before the committee of creditors. And here I have to make one very, very important observation, sir and Dr. DHANAPAL. The claim here, the claim is actually the most, it is the unseen process, but the biggest headache for the resolution professional, that the entire headache is transferred to CD. CD has to give the list of claims to the resolution professional. and if at all he misses it, then the respective creditor can haul him in court of law. That is the biggest challenge, because that means people have to be transparent. People have to be transparent, and the law gives them the due respect. So 120 days, 90 days for resolution plan approval, 30 days for my lord to actually give the order. Now within 90 days, you have not, there is no plan that has been, only people have been doing jagada and jamela, no plan, very clear, the PP, IRP will be terminated. Matter over. Thank you.
So, thank you, Dr. Raju. 90 days plus 30 days is the crux. And in addition, I understood, take a cue from you. You have to correct me whether my understanding is right. Before giving an application before my lords, there should be a pack ready with respect to the CD concern. Otherwise, that within 2 days, he cannot do things. So, the first homework from the CD end is to take the stock of the situation, prepare a plan, and discuss and engage a professional and keep things ready, then set the process in motion so that on the commencement date as approved by the NCLT or your honors, my honors, and then within 2 days he has to submit a plan. So that is very, very relevant. There, the role of the data, that is information shared by the CD, is very, very vital and important. Now, you have made a good observation in your reply and view that the creditor-centric or debtor-centric management. Prior to this insolvency process, prior to 2016, the defaulter continues to be in the management. Dr. DHANAPAL ji, prior to 2016, the defaulter jolly well continuing whatever that he wanted prior to this particular banking law, or for this IBC reforms committee or whatever that they were doing. Now, the process 2016 code has been in vogue even today, that is continuing. There is a new dispensation under this ordinance. The management continues to be under this pre-pack period with the management. And what is the implication with respect to moratorium and continuing the management of the affairs of the CD or the MSME concerned during this pre-pack insolvency resolution plan? Dr. DHANAPAL ji.
Yes, sir. See, now I will try to explain you the normal process, how it is followed, then what is going to be the process which we could understand from the ordinance. Probably the normal routine CRP process, we have already gained experience by handling matters, corporate debtors. Probably this pre-pack insolvency, we have to handle it in practical sense. But what is there in the ordinance? What is the process prescribed in the In the normal CRP process, what happened under section 7 or 9, an application is moved, or section 10, corporate debtor themselves move an application before Honorable NCLT. Now, what happened in pre-pack insolvency, as I already observed, this corporate debtor, after passing a special resolution, after having their own pre-pack, a base resolution, they have to approach financial creditor, and the financial creditor has given in principle approval for corporate debtor to proceed further with the pre-pack insolvency by nominating one of the RP. In fact, the process starts just like how section 7, 9, 10, the process starts by filing an application. Of course, the regulation yet to come. IBC has to come out with the regulation and related rule and forms. Of course, the amendment also has been made enabling to make all that regulations and rule. So we have to wait and see what kind of format is going to be introduced for filing the forms and application. Just like how section 7 and 10, 9 and 10, where then application will be moved. Similar way in pre-pack insolvency also, an application has to be moved before the Honorable NCLT after taking approval of the financial creditor with the name of the IP nominated. So after hearing the application, the Honorable NCLT will order, just like I owe like a CRP, same way pre-pack insolvency commencement date will come into force. on the date of admission of the application. On the same date of application, the IP appointment, the RP appointment also confirmed. Here, one small change is that in a normal CRP process, when the CRP is admitted, IRP starts its process. But here there is no IRP. Directly the RP only is appointed. So RP takes in charge of the whole entire thing. Now again, if you see the difference between the routine CRP process and the pre-packed CRP process, the difference is that there in normal CRP process, the IRP is under obligation to take the custody of the management, the responsibility of the all the assets and duties of the suspended directors. So actually speaking, the suspended director is kept away from the day-to-day affairs of the company and other decisions of the company, where the entire decision, entire responsibility comes in the hands of the IRP. Here, the idea of the government is not that to send away, to throw away the management in this pre-pack insolvency. The idea of the government is that with the support of professional, see that how the corporate data, they themselves analyze their position, come out with their own package with the consensus of the financial creditor, taking their approval, then filing an application. Then once the order has been passed by Honorable NCLT, admitting the application. Similar way how it is done in section 10, similar way it is done in pre-pack also. Probably there won't be any change. We have to wait and see. But same application process, same timeline. The Honorable NCLT should admit. The moment the application is admitted, the moratorium starts. Here, one important difference here is the management is in the hands of the same person. The management is not changed. The property custody or the affairs of nothing will be changed. But one important provision has been inbuilt is that the moment the application is admitted, the provision says that all the financial institutions, bankers, has to cooperate. All the personnel and directors, all the employees of the company should cooperate to the resolution professional to see that resolution professional executes all the responsibility, obligation, functions, whatever provided in the ordinance. So purely resolution professional will be giving in a helping hand, of course, with a lot of responsibility and to ensure, and also to ensure the compliance aspects. But he is not taking custody of anything from the management. It is very much with the same in the hands of the same management, and with the help of the RP, the pre-pack insolvency will be explored.
So, Dr. Dhanapal ji, the understanding is entire process like in a CRP is similar with respect to application,
yes,
hearing by the adjudicating authority, appointment of a professional, be it IRP or RP in this case, and also with respect to moratorium. Correct?
yes.
So, that the only change is the application is to be initiated or moved by the MSME himself.
Yes.
There is no 7, 9, 10 when he starts the move. That's the major distinctive point, which what I understood with respect to your deliberation or a dispensation. Now, yes. Dr. Raju, in a CRP process, there is a called information memorandum to be prepared. Within so many days, it has to be prepared and presented with all the details before the possible resolution applicants or whatever that process goes on. Now, is there any corresponding preparation of an information memorandum under this pre-pack period, and what are the intricacies under the ordinance? Dr. Raju.
Sir, very interesting question. There are two new term. It is, we can call it as a pre-pack resolution plan, a pre-packaged information memorandum. So pre-pack resolution plan, they have called it as a base resolution plan. Now, the moment you call it as a base, that means you have other resolution plans also. Yes. So that is why the base resolution plan, for example, the total, let us be very practical. MSME has borrowed from 17 creditors. Put together, the total loan is, say for example, 93 lakhs. Now, I come out with a base resolution plan. See, 93 and all not possible. I will settle it in 63. This is the plan I give. So 63, I have some method. I will bring money and I will settle it. My own money I will bring and settle it. My assurance. Or you go with the other CRP normal process, you do it, nothing will come. I am assuring 63. This is base. So that is why once the corporate debtor, this section 54G subsection 1 very clearly says the corporate debtor shall within 2 days of the pre-packaged insolvency commencement date submit to the RP, because it is already pre-packaged, because I already know what is my strength. It can even be out of 93, I will even say I will only give 23. Balance Govinda. Okay, so that also is possible. So I will give this first, what do you call it, as a base resolution plan, and I must also give the preliminary information memorandum. So there it is IM, here it is PIM. And there it is in CIRP, the IM is prepared, the responsibility of the IM. Any mistake in the IM, the creditors will pounce on the RP only. So here it is very cool. The preliminary information memorandum has to be verified. So RP's role is like an auditor role. So he's like an auditor role, he has to verify, he has to prepare reports based on this, whether it is correct or not. So therefore, preliminary information report containing information relevant for formulating a resolution plan. Now, why this preliminary information memorandum? Because base resolution plan and further resolution plan for inviting other resolution plan from the prospective resolution applicant, and those plans along with the base resolution plan will be kept on the table of the committee of creditors, and a better, I repeat the word, a better resolution plan. That is why 54K subsection 10, 54K subsection 10 very clearly says, where on the basis of the criteria as may be laid down by it, the committee of creditor decides. I repeat, the committee of creditor decides that the resolution plan selected is significantly better than the base resolution plan. So the committee has been given that power. So the platter has to be kept before the committee. And there is one more very, very interesting powers given to the committee of creditors. I have to actually bring it to your attention, sir. Here, the committee of creditors can take the control where two exceptional circumstances. See, I mentioned it is monorail, it is two rail battery. Now, in pre-pack, it is two rail. Who are the two track? One track is RP, another track is board of directors. Now, this two track will go together provided everything is going on smooth. If two exceptional circumstances are there, what is exceptional circumstances? Affairs of the corporate debtor have been conducted in a fraudulent manner, or there has been a gross mismanagement. Take the loan and use it for all nonsense purpose. Then committee of creditors can decide with 66% majority that suspend that board. And just because committee decides for suspension, so that is why in the first meeting in the CIRP, honeymoon period is 30 days. Honeymoon period is 30 days. In pre-pack, honeymoon period is only 1 week, 7 days.
7 days.
7th day, meeting has to be started. Financial creditor has to decide whether monorail or normal rail track. Monorail means I have to actually take a decision to send the board, send the board suspend. But in CIRP, once an order is passed by AA, board is suspended. But here, committee, once they decide, the RP has to go before the what do you call it as honorable NCLT, my lord, and then say, my lord, fraudulent manner they have done or mismanagement. So that means my dear resolution professionals have a very, very important role to collect lot of evidences. For fraudulent manner, it is very serious. For mismanagement, lot of accounting details will be there. So they can present it and convince my lord, sir, only one king, no two king, only one king for the next 120 days. So this is going to be a very interesting circumstances. I am sure Mr. DHANAPAL will agree to it, and Maybe he can supplement some.
Dr. Raju, you are telling there is a different kind of a challenge or a situation for a professional in the sense under the CARP, claim validation approval listing is a challenge within the given time and also to present it, take the confidence of the COC. Here, the fraudulent or mismanagement is not there, is to be excluded before taking further action because time available is very, very less. The practical scenarios of so many situations may erupt for the professional also in come to the conclusion about this one. That's a very nice aspect. And Dr. Dhanapal ji, I make an application as an MSME before their lordship for any reason. If my application is rejected or whatever reason, what are the consequences under the CARP? If the process or resolution plan files or something, then there is a corollary or a natural consequence that the lordship may order for a liquidation of the CD. Now, what is that scenario in this pre-pack process?
Actually, the scenario, if you see, as I already deliberated, there is not much difference between the CARP and pre-pack insolvency, except RP is kept outside, of course, with the responsibility and obligations, not within the management, outside the management. That is the main difference that is there between the CARP and pre-pack insolvency. CRP, RP is given in hand the entire management of the company as well as the custody of the assets and taking care of entire control of the assets and affairs of the company. Where here in pre-pack, the entire management and custody, all that they're in the same hand, which I already told you. So RP is supporting only. So here what happened, as Dr. Raju said, if the COC able to convince themselves that there is a fraudulent activity took place or something is done by the corporate debtor to defraud the creditor, then the COC can pass a resolution and say that to take custody of the entire management as well as custody, just like a CRP process, to take custody of the entire management. Then it will become a routine CRP process. How it happened, but of course, there's no change in the timeline, everything. But the responsibility wise, I'm saying it will become all the more the routine CRP process. Another important aspects here, if you see, even the COC member, after constitution of COC, okay, after the base resolution plan is prepared and presented, and after resolution plan has also been invited from resolution applicant other than the base resolution plan, if even in that stage, if the COC member felt, means in the meeting, if the COC members felt in their meeting that the plan is not going to work anymore, and there is no question of considering any plan because nothing looks working, then the COC can even take a call to decide that company can be taken into liquidation directly. So in which case...
So Dr. Dhanapal, sorry to interrupt Dhanapal ji. Now, yes. The pre-pack process is on, and during the pre-pack process, COC in their meeting with all their wisdom to decide that pre-pack may not work. Why should I not go for a CRP, including liquidation or whatever? Can I go and by a due process of a resolution and giving a petition before their lordship, they can seek a direction to stop the pre-pack and initiate CARP. Correct? My understanding is right?
Yes, I'll put it. Okay, I'll put it a little more clarity. If you see in pre-pack insolvency process, three things is important. Three scenario I can say. Then the three scenario is important because that's very important to understand when we read ordinance, which we could understand from our ordinance language. See, one is, as Dr. Raju said, when there is a defraud of creditors or where there is a transaction is done for some fraudulent purpose, then the COC can decide to pass a resolution, authorize the RP to take entire custody of the property and take custody of the management of the entire affairs of the corporate debtor. That is one thing. Second, even during when consideration of a resolution plan before the COC, still COC can take a decision that something has gone wrong in the affairs of the CD. Therefore, the COC can say RP that the CRP process initiation also can be done. In fact, there's a provision whereby the COC can even authorize that regular CRP process also can be initiated against the company, and there's no longer of a prepack insolvency, authorizing RP to file a termination of prepack insolvency process and authorizing RP to initiate CRP process. This is second.
Dr. Raju, anything you want to supplement on that, Raju?
That within the 90 days.
Yeah. I
have hours. Beyond 90 days,
but
time
again,
is the correct.
Correct. But again, once CRP is admitted, then we get a timeline. Once CRP is admitted, we get timeline again. We get normal CRP timeline. So what I'm saying, the carrying out of filing an application under regular CRP, that should happen within the timeline. Once CRP admission took place, then the CRP timeline starts. That's what the ordinance says. That's the second scenario. Third scenario, when the resolution plan before the COC member, if, as I told you already, that when if the COC members felt that this resolution plan is not going to work anymore, then the COC can directly authorize and pass resolution that company can be
well taken. Point well taken. There can be a direct intervention by the COC to stop the process and go for the regular CRP. That's the point which you are highlighting. Thank you very much.
As well as liquidation.
Whatever that, what is the CRP and also
direct liquidation also.
Direct liquidation also. Without the CRP, direct liquidation also. Thank you. Yes. And Dr. Raju, I would like to know one important short point on that. Time is running out. 10 seconds.
Yes, sir.
In case my PPIRP process gets rejected, is there a mandatory condition I should go for a liquidation by the company like in a CRP or anything? Raju,
no. Very interesting. Very interesting. So there it is by default. By default, you are pushed to liquidation.
Yeah.
So here the PPIRP is terminated. That's all. And after that,
MSME can safely initiate the process, try and sincerely do. In case some for reason nothing happened, they are not going to lose anything. So it's a great boon.
That is why, sir, this is a safe route. PPIRP is a very, very safe route, and that is the objective of the government to actually make it more popular. And even non-MSME, they may reduce their investment and their turnover and demerge it and make it into a MSME also. Number one.
Thank you, Raju. Short point, last 1 minute. Sorry, Raju. Dhanapalji, last 1 minute, 60 seconds only for you. Kindly share your supplemental, whatever points, 60 seconds only. So finding up remarks so that Raju will take
you give me another 60 seconds, sir. I want to make a last only one very important point.
Okay. See, just to supplement Dr. Raju, what he said, provided the MSME should come in clean hand. If MSME, the corporate debtor is not in a clean hand, then the COC, as I told you already, can take a decision to initiate CRP or to take a decision to initiate liquidation. That is one thing. Before closing, another very important aspect I will say and conclude. Here in the prepack insolvency, the very important responsibility given to the promoter is that whatever the information shared by the promoter of the corporate debtor should make sure that the information shared are proper and all are legally right. In case if any loss suffered by any person because of the wrong information supplied in the preliminary information memoranda, then the third party or any person who lost, relying on the information, if would have incurred any loss, in fact, he can claim the loss in the civil court. He can make the promoters liable and claim the loss, even civil court. That is a provision, as a new provision which we could see in the prepack insolvency process, which is not there in the regular CRP process.
Maintaining the preeminence of IBC, there is a way given for this recovery of this money also or process. Raju, your summary point.
In CIRP, the wordings is called as verification of claims and then maintain the updated list of claims. Here, the wording is called confirm the list of claims, because the claim is actually given by the corporate debtor. Number one. Second, inform the creditors. Now, how do you confirm the list? How to confirm the list of creditors? They say in such a manner as may be specified. Again, they will mention the regulation, what steps you have to follow. So accounts if it is there, any document if it is there. So this particular IRP is going to give you a lot of clarity with respect to confirmation of claim, and then informing that that you are actually, this is your claim to the creditor. Informing, this wording was not there, but by default we have been doing it. Once the verification of claim is over, it is a best practice the RP used to inform the creditors, but here they have made it very clear that particular gap has been identified. And last point but not the least, they have made it one very important observation that since it is a parallel rail track, the management of affairs will be done only by the board of directors. And what is the role of RP then? RP will only monitor. And they made one very important wordings there. It is called as inform the committee of creditors. So they are the mouthpiece of committee of creditors. In the event of breach of any of the obligation of the board of directors, that means, my dear resolution professionals, you have to be very thorough in Income Tax Act, GST Act, PFI, ESI Act, all the labor laws, and all the 180 laws which is applicable for a corporate law, corporate world. Otherwise, we will be failing in our duty in informing the breach. Number one, with respect to compliance of the law. Number two, with respect to the compliance of the contractual obligation. Both, it is the obligation of the RP. So thank you very much, sir.
Thank you. I will say a few words and conclude. Thank you very much, Dr. KRISHNA RAJU and my dear friend, Company Secretary, Dr. S. DHANAPAL ji. Within the given, with the shortest possible note of less than 36 hours of unfolding of the ordinance, with all your rich experience and going through the provisions for the sake of this meeting. It's only initiation of understanding and appreciation of the provisions with respect to your experiences. Dear participants, you have raised certain questions. There is no time available right now. And what we wish is, we'll continue to have this type of deliberations and sharing of knowledge by the experts like Dr. KRISHNA RAJU and Dr. S. DHANAPAL ji in the days to come. Kindly bear with it. There was one question about a PUEF, which is 43, 46, 50 and all. I would request Raju to 30 seconds only to say whether PUFE transactions are applicable or whatever the question. Address, there is one that is from Dwarakanath Acharya ji, and one more question by other member, that is for DHANAPAL ji. With that, we will have a great day with respect to sharing within 36 hours of unfolding of the ordinance. Great. Thank you very much. And Dr. Raju.
Sir, as I was mentioning about the duties of the RP, like confirming the list of claims, informing the creditors, monitoring the management, in the same section 54F, subsection 2, subclass H, they have repeated the duty of RP or liquidator, which has been given in chapter 3. They are repeated in chapter 3A also. File application for avoidance of transactions or fraudulent or wrongful trading. It has been given. So it is my responsibility.
Prepack also, it is onerous duty is cast on the RP to take care about the CRP process. What is there in 40, same. And one more question was there. Am I remember correctly, Raju? One more question was there earlier. Dr. DHANAPAL ji, with this, we will like to have your great views on that. Swiss carbon or something, there is a question.
See, it makes very clear that the base plan, it should not impair the rights of the OC. If it impairs the rights of the OC, then base resolution plan cannot be approved by the COC. That means the base resolution plan not only should address the FC and also should take care of the OC. Probably we have to wait and see what the regulation is going to unfold. Probably the regulation will make it clear furthermore these aspects. So as of now, the base plan should address both FC as well as OC.
Sorry, DHANAPAL ji, I remember 253, the benefit that is arising out of the plan for a OC should be more than the FC. There is a requirement also. I think without meeting that requirement.
Yeah.
And see, sir, actually, I want to just supplement this. They have actually amended section 239 and 240 also. And 239 is for 2 rules. They are going to bring 2 rules for this.
Yes.
And another 15 minimum regulations, or they may package into 3 or 4 regulations with respect to pre-pack IRP. And one of that, they are going to bring what will be the minimum content in base resolution plan. Number 2, what will be the information that has to be given in the preliminary information memorandum, and based on the preliminary information memorandum, it will be actually confirmed by the RP, and an IM will be prepared by the RP that has to be placed before the COC, because that has to be given to the prospector resolution applicant.
Sir, before
Thank
closing,
you very much. Thank
yes,
you.
sir.
Sorry.
Before closing, if you see the pre-pack insolvency provisions, it has made many of the already the whatever the available provision, prevalent provision, many of the provision it says mutatis mutatis, this is applicable to pre-pack also. It is not that pre-pack we can ignore the CRP process. In fact, section 26 to 30, it makes it clear that entire provisions are applicable. Mutatis mutatis, whatever is applicable, they are supposed to follow that. It's not that one can skip completely the CRP provision. So whatever is applicable, so whatever the situation it may applicable, all are applicable to pre-pack also. So it is not that sufficient reading only pre-pack insolvency and complying it. It is also important parallelly the CRP provisions or liquidation provisions also is as applicable. Okay. So the mini provision, yes.
CARP process, the approach and the process involved is equally applicable in respect of this pre-pack process also, except those special provisions that have been made under the ordinance for a pre-pack situation.
Yes.
Correct? Can we understand like this, Dhanapal ji?
Mutatis, few of the provision is made applicable.
Thank you very much. Words cannot express the feeling of gratitude for that great preparation and presentation by 2 great stalwarts in this profession, Dr. KRISHNA RAJU and Dr. Dhanapal ji. Thank you very much. Thank you, my dear participants.